Good morning and welcome to all of you for Veranda CA's session, RTP session on corporate laws. So the the flow of the session will be like, we'll take up each question, and then if there are doubts, we'll answer it question by question before we proceed to the next one. So let's go to the first question. Mr. Ram and Mr. Mohan were appointed as whole-time director and managing director of Gopi Industries. Raja Limited, a holding company of Gopi Industries, was willing to appoint Mr. Ram as its whole-time director and Mr. Mohan as its managing director. Enumerate the legal provisions as regards holding of office by KMPs and decide on eligibility as its key managerial personnel under Companies Act in Raja Limited. What if the office of Mr. Ram is vacated due to sudden resignation given on 1st September in Gopi Industries Limited? When you look at this, the question looks very circuitous. So let's break the question. Ram and Mohan were already whole-time directors, key managerial personnel of Gopi Industries. Gopi Industries is held by its holding company, Raja Limited. Now, Raja Limited wants Ram and Mohan as their whole-time directors also. Can a person be a whole-time director in two companies, which is a holding and a subsidiary company? And what are the eligibility conditions, if at all? And if the office of Ram is vacated due to sudden resignation given in Gopi Industries, can he be appointed in Raja Limited? So let's go to each of those things. Under section 203, we talks about KMPs and whole-time directors. A whole-time key managerial personnel shall not hold office in more than one company except in its subsidiary at the same time. It never talks about in its holding company. The KMP is nothing but the whole-time director, the managing director, the CFO, the company secretary, or any other person nominated by the board in their absence. So it says a whole-time key managerial personnel shall not hold office in more than one company except in its subsidiary. Here, GIL is a subsidiary of Raja Limited. Raja Limited is the holding company. Here, the holding company would like to appoint somebody in some whole-time members of the subsidiary company. It also says that nothing contained in this subsection shall disentitle the key managerial personnel from being a director of a company with the permission of the board. It also says that a company may appoint a person as MD of one and not more than one, provided it is approved by way of a resolution at the board where consent of all the directors are present and a specific notice is moved thereat. So in the above question, if you see, Ram cannot be appointed because Ram is not a KMP of the holding company. Ram is already not holding any office in Raja Limited. The question is, Raja Limited wants to appoint the KMPs of subsidiary in its company, which is not permitted. However, it says Mr. Mohan can be appointed as managing director if the conditions are complied. What conditions? As we said, that it has to be passed by way of a resolution. It has to be an unanimous resolution. Unanimous is different from ordinary or special. Unanimous means there cannot be a dissenting vote. All the directors present will have to agree to the resolution. Therefore, Mr. Ram cannot be appointed because of the whole-timeness, whereas I can be appointed as a managing director in not more than one. That is, you can have two, not more than one is what is the law. So you can appoint it as MD in other company also, provided an unanimous resolution is passed. Unanimous means all the directors must say there shall not be a dissenting note. It also, the next question is, what if he resigns? If he resigns on 1st September, the vacancy should be filled in by the board within 6 months. That is what the law says. Any doubts in this question? The answer would have been much different if they are in Raja Limited and they would like to be appointed as a whole-time director in the subsidiary, which is possible, but not the reverse, is what is the key here. Earth Developers Private Limited, a Bengaluru-based company, is regular in filing annual returns. and is having four directors, but no MD has been appointed. Due to the increase in construction, it is felt that they need to urgently fill in. Accordingly, Mr. Pranav is appointed as MD by the board. Enumerate the provisions and the requirements of the law and the validity of appointment of Pranav. So the question here is, it has 4 directors, but no MD. But considering the increase in business, they need to appoint an MD who is a whole-time director. 1 minute, I'm sorry. So they would like to appoint a person as whole-time director, as managing director. So the question is, can he be appointed by the board? And what are the provisions in this regard? And the company happens to be a private limited company. The private limited company are exempted from the provisions of, by way of notification in 2015, they are exempted from the provisions of appointment of managing director by following a different route which public limited companies take. That is, they'll be appointed by the board and it is subject to approval of the shareholders. And if the shareholders doesn't agree, then he has to vacate office, and the appointment has to be done in accordance with, profit making, non-profit making, etc., etc. But those are not applicable for private limited companies because they're exempted. So therefore, section 196 requires that every appointment of MD shall be made at the board, and it has to be subsequently approved by way of a resolution at the next annual general meeting. And if there are variations that are from Schedule 5, as I said, inadequacy of profits or loss of, are the company is making continuous losses, or is a non-resident, or it doesn't fulfill any of the conditions specified in Schedule 5, then you'll have to go to the central government for its approval. But here, because it is going to be a private limited company, the appointment can be made by the board directly. He can just go ahead but get the approval of the shareholders at the next meeting. Therefore, the question that the appointment of Mr. Pranav as MD by the board in the board of Fourth Developers Private Limited is valid. It doesn't require shareholders approval before his office. No, he can be appointed and subsequently go to the shareholders for approval. Therefore, the act of the board of directors in appointing Mr. Pranav as MD is valid. So we'll go to the next question. Mr. Sharif, who was a key managerial personnel of XYZ Limited, retired on 12th May 2020. An examination of the accounts of the company for 31st March, the registrar of companies found some serious irregularities in write-off of huge amounts of bad debts, and no satisfactory explanation was provided by the company. In such a situation, the registrar of companies wants some explanation from the company, and Sharif, in the light of Companies Act, examine the situation and advise on the act of registrar seeking explanation from Sharif. Now the question here is that, can the registrar go and approach a person who is retired from the company now after the books are finalized? Can subsequently the registrar go to the retired employee and seek his explanation? Under the earlier law, it is different. Under the new law, it is different. In the 1956 Act, they cannot. Whereas under the 2013 Act, it provides so. Under section 206 of the Act, the registrar can ask for any information or any documents from the company or its officers whom it thinks fit that it is necessary that for the investigation of this matter or deciding anything on this matter, that such a calling of information or document or seeing that person is mandatory. It also provides that if the investigation has to happen by a scrutiny of accounts in the previous periods, it has the power to call for explanation from the officers who were in employment during those periods by serving an appropriate notice. So it typically means that in the instant case, even though Mr. Sharif has retired, but all these huge write-offs and the matter to decide this has happened during the time when Mr. Sharif was in employment. So in this case, Sharif was in employment as on 31st March. He only retired on that day. The registrar is wanting to investigate those affairs where Mr. Sharif was already in employment. Therefore, the registrar asking for information from Sharif is perfectly valid, provided there is Mr. Sharif would have been an employee and he has been served an appropriate notice in writing by the registrar, in that case, registrar can approach an ex-employee for any information. Any doubts in this? So let's go to third question. Surya Limited wants to reorganize the company share capital by consolidation and passed a resolution and thereafter made an application to the tribunal. The tribunal ordered that the meeting of the members be called. The company sent notices to all members. In that meeting, some members made an objection to the arrangement. However, majority were interested. The tribunal, after scrutinizing, sanctioned the proposed arrangement. Examined under the Companies Act, that in order to give effect to this, consolidation of shares and therefore reorganizing, what are the provisions of the law under the Companies Act 2013 as to what you must do? See, consolidation or reorganization of share capital will amount to a compromise or an arrangement as specified under 230 of the Companies Act. Not necessarily amalgamation or a demerger is a scheme of arrangement. No, that's not the case at all. Nor demerger or an amalgamation is a scheme, is a type of arrangement, it's a type of compromise. Consolidation is also a type of compromise. It can be between company and the creditor, company and the member. But the moment that you would like to have an arrangement or a compromise with the company, that is between a creditor and the company or creditor and the member, it has to be done with the approval of the tribunal. The moment you file an application with the tribunal will call by an order that the meeting of the creditor or class of creditor, member or class of members be conducted to take approvals for the particular case of compromise or an arrangement. In the question that we are going to see, it's not a matter of creditor, it is a matter of members. So the tribunal may order the calling of a meeting with the members of the company. That's the first point. That is, this will amount to a scheme of arrangement falling under section 230 is the first point. The scheme of arrangement can be between member and the creditor, the company and the creditor, and the company and the member. However, if you are going to have it with the member, creditors need not be called for right away. It is enough if you call only the meeting of the members. But the meeting of the members have to be called only by an order of the tribunal, that is the National Company Law Tribunal, not the company on its own. Hence, the term arrangement includes reorganization of share capital or consolidation by all the methods. Any compromise or arrangement needs a sanction by the tribunal. Only after the tribunal gives an order, you may call for the meeting. And after the meeting is over, you will have to forward the minutes to the tribunal for further orders. And the copy of the order of the tribunal will have to be filed with the registrar. The tribunal may dispense if they have already the consent of all the shareholders, at least 90%, they may dispense with other set of meetings. Question number 4. M, a member of XYZ Limited, filed an application complaining oppression and mismanagement with respect to an agreement by XYZ Limited. While order passed by the tribunal under 242 terminated the said agreement. The agreement was entered by Mr. H and Mr. G, who was managing director and executive director. Mr. Rashik, with whom XYZ Limited had entered, filed a petition claiming loss due to the termination. Also state the legal provision of H holding their office in that situation. Given these facts, please address the issues in terms of Companies Act. See, oppression and mismanagement are a typical armor to the shareholders when an alleged act of irregularity ratified or capable of being ratified is taking place in a company. So when there is an oppression and mismanagement, any shareholder can approach the National Company Law Tribunal saying that there is an oppression and thereby setting aside certain contracts or certain transactions that had taken place during that time. So here there has been such an agreement, it has been terminated by the order of the tribunal. Now, the person who is affected, that is Mr. Rashik, with whom XYZ had entered into an agreement, is now claiming for loss because there is a termination, therefore they're claiming loss. But it asks what is the provision of the law under the Companies Act that when there is an oppression and mismanagement and the order has been set aside by the Company Law Tribunal, what is the provision of the law? See, normally if I violate the terms of the agreement, I'm entitled to loss. Any agreed party is entitled to a loss. But here the agreement has been terminated not at the instance of the company, but by the order of the tribunal. So let's see what that provision is. Under Section 243 of the Companies Act, where an order under Section 242 sets aside or modifies any agreement which was in the manner prejudicial to the interest. Suppose the agreement is in the manner prejudicial to the interest of the company, then such an order shall not give rise to any claim against the company by any person. So in this case, the agreement was found prejudicial, and it was an operational mismanagement claim which was filed with the NCLT. The tribunal has passed an order. So therefore, the tribunal has found that while passing its order, it found that this agreement was prejudicial to the interest of the company, and therefore it has set aside the agreement. Therefore, the person who has claimed any loss has no valid grounds to make that claim, and therefore, the claim made by the person who has suffered a loss is not valid. It also says no MD or other director whose agreement is so terminated shall set aside for a period of 5 years from the date of the order without the leave of the tribunal. So it says that you have an agreement with the managing director, it shall not be set aside or terminated. And even if it is terminated for a period of 5 years without the leave of the tribunal, you cannot set aside the agreement. It has to be continued, and the validity of the agreement may go, but it cannot be set aside. The order of the tribunal has to be understood. The tribunal may say that you may set aside the agreement, but the compliance of the agreement, which was that is prior to the order, shall be complied with, and therefore Mr. Raseek, who's claimed loss, cannot claim a loss, and his claim is not valid. Further, Mr. H and G, who are managing director, who entered the agreement, was ordered to be terminated, shall not act as managing director of the company for a period of 5 years. So in this case, there is an order which also sets aside the office of the managing director themselves. So therefore, that is also not valid for a period of 5 years. And if you have to get exempted, take the approval of the, see, it says without the leave of the tribunal. Leave means nothing but a permission. Suppose you would like to set aside, so take the leave of the tribunal and then execute the agreement. It simply says if an agreement has been set aside due to the order of the tribunal, don't do it at the first instance. If you would like to do it, go to the tribunal, take their approval, and then do it. If the order of the tribunal also says that a managing director or any person cannot hold office as such, the office of such person has to be vacated immediately. So we'll go to the next question. Doom Limited wants to reduce the rank of Mr. Happy, the CEO of the company, during the pendency of investigation being conducted on the order of the tribunal. Doomed Limited made an application to tribunal regarding the reduction of rank and received an objection of the tribunal on 29th May 2020. What course of action or remedy is available to Doomed Limited and to Mr. Happy as per the provisions of the Companies Act? Section 218 of the law says, if during the investigation of any matters, I mean, this is typically coming under any investigation or inspection under section 209 and 210, subsequently with 212 of the Companies Act. The ownership of the shares or any of those things or relating to any of the matters relating to the company, then during the pendency of the proceedings by the registrar or by the tribunal, that is typically when an investigation is happening on the legal ground by the act of the tribunal, then such company, if it proposes to discharge or suspend any employee or punish him by way of depromotion or reduction in ranks or change the terms of the employment, it shall not do it without the prior approval of the tribunal. This is, a tribunal is already investigating. You cannot impose penalty upon a person. Everything will remain status quo. So if you have to reduce a rank of a person, or you want to demote him, or you propose any other action, you are required to apply to the tribunal, take the leave of the tribunal, and then only do it. But in this case, the objection of the tribunal has already come. So the tribunal has objected to the reduction in the rank of the respective employee. Therefore, you cannot do it. So where if no objection is received, if the company doesn't receive any 30 days of the application, the company can proceed against the action proposed. If it comes, if the objection is received, the company within 30 days of the receipt of objection make an appeal to the tribunal as to why you are doing it. However, the order of the tribunal, of the appellate tribunal, National Company Law Appellate Tribunal, will be final. Till such time, you cannot suspend, you cannot punish, you cannot demote, everything will remain status quo. So if no objection is received within 30 days, take action. If objection is received, don't take action. But if you still find that objection has to be made, make an appeal to the National Company Law Appellate Tribunal, and the Appellate Tribunal will pass an order that will be binding on the Appellate Tribunal, company, and every other person concerned. So in the above question, Doom Limited have received an objection within 30 days, and therefore Doom Limited can prefer an appeal to the Appellate Tribunal within 30 days. Till such time, the company or the employee cannot, the company cannot punish an employee or wait till 30 days to see if there is any action that is required to be taken. So Doom Limited has 30 days time to file its appeal before the tribunal against Mr. Happy. Till such time, Mr. Happy's employment will continue to be the same and no reduction in the position as Chief Operating Officer.